Messina, now is your turn not to testify. You will be given an opportunity to do that. You may now cross-examine the officer.
Thank you, Judge. Deputy O'Toole, did you get any special training to be a deputy?
Yes, I did.
What did that consist of?
Went to the police academy, and also when I got hired, I went through 20 weeks of field training.
Went to what, sir?
I went to the police academy,
And then what?
and when I got hired through the Waukesha County Sheriff's Department, I went through 20 weeks of field training.
Have you studied the Wisconsin traffic statutes?
Directly?
Just answer the question.
Yes.
Yes, you have. Okay. Have you studied the municipal ordinances of the town of Lisbon?
Yes, I have.
Do you make legal determinations when you apply the law?
Can you speak up, please?
Do you make legal determinations when you apply the law?
Objection, no.
I think the officer can answer that.
Can you repeat the question, please?
Do you make legal determinations when you apply the law?
Yes.
Okay. Are you an expert in the interpretation and application of the Wisconsin Constitution and state statutes?
An expert?
What's the relevancy, sir?
I'm inquiring about his capacity and competency to make legal determinations when he applies the law.
What does your question have to do with this speeding ticket?
He made a determination that the laws of the state of Wisconsin apply to me. And I'm going to be asking the deputy, what facts and evidence does he have to back up his belief that the laws of the state of Wisconsin apply to me? So that's why I'm asking about his competency in that matter, sir.
Okay, the officer can answer.
I've been trained to apply the laws. I would consider that. I don't have a title of expert.
Okay. Have you ever been investigated for any actions you have performed as a deputy in the sheriff's department?
Sorry, what do you...
Just answer the question, sir. Yes or no?
I don't understand the question.
I'll repeat it then. Have you ever been investigated for any actions you have performed as a deputy in the sheriff's department? Yes or no?
Again, I don't know what you're referring to. I don't understand the question. Investigated.
It's a simple English question, sir. Do you want me to repeat it again?
I will repeat. While employed as a deputy with the Waukesha County Sheriff's Department, have you ever been investigated by the Sheriff's Department? Yes or no?
Yeah.
Yes, you have. What was the nature of that investigation, sir?
The complaints regarding a crash.
Okay. I'm accused of violating the laws of the state of Wisconsin. Is that true?
Yes.
Do these laws apply outside the state of Wisconsin?
Irrelevant.
Sir,
Sir, irrelevant. We're not dealing with the law outside the state of Wisconsin.
okay. Is it your opinion, Deputy O'Toole, that I was within the state of Wisconsin?
Yes.
Is that an arbitrary opinion, or is it based on facts currently within your knowledge?
Sir, his testimony was that he stopped you in the town of Lisbon in the state of Wisconsin. What more do you need?
Are you...
State fact.
Okay. That's your opinion. Judge, are you allowed...
That's not my opinion.
Judge, are you giving evidence, sir? Are you providing evidence, sir?
I am telling you what is in evidence. You have a Wisconsin driver's license. Now we've already talked about that. You were stopped in the town of Lisbon. The deputy testified to that. That's in the state of Wisconsin. He testified to that. He is an employee of the Waukesha County Sheriff's Department. He was on duty. He had the right to stop you. He had the right to question you. And he had the right to cite you for a violation as he understood it and saw it. And that's what we're here for, sir. Whether or not you were guilty of that. And I will make that determination.
Sir, are you providing testimony here today?
No, I would provide testimony.
Then would you let the deputy respond to my question?
I certainly will, to a reasonable question, and you are being unreasonable, sir.
I'm asking
You
you.
are being unreasonable. The matter is in fact, we don't need to have it 16 times. It's been stated, I have clarified it for you. That is not evidence, that is a clarification. Judges have the right to do that.
And I have a right to seek the facts and evidence that...
You do, you do.
And I'm...
Right to seek the facts, not to be argumentative and not to be all over the place. Stick to the facts of this traffic ticket, sir.
Sir, is it your presumption that the codes and statutes of the state of Wisconsin apply to me because I'm physically...
Irrelevant, sir. I have already stated that they do apply. I've made it eminently clear to you that they apply and you are subject to them. Proceed.
Okay, just a second. Deputy O'Toole, did you file a valid cause of action against me?
Irrelevant.
I'm sorry, sir. Is this complaint not a cause of action?
It's a ticket. He issued it to you. What more do you need sir? How many times does that?
Would you take judicial notice of State Statute 345, Section 311(8)? Would you take that judicial notice? Number 8, any person who with criminal intent solicits or aids in the disposition... I'm trying to cite your statute, sir.
Stop. You're citing the wrong statute. It's not applicable because this is not a criminal action.
I'm citing the traffic state in the code. It says that...
Criminal. This is not a criminal action.
I'm not citing the traffic... Let me finish.
You just read it.
I didn't even finish reading it, sir.
You don't have to. I don't need to. It's irrelevant.
It says attempted disposition of a uniform traffic citation in an unauthorized manner is in contempt of the court having original jurisdiction in the cause of action. The statute...
Criminal.
No, it's not criminal. It's a unit. It says a uniform...
Read the first sentence.
Any person who with criminal intent...
You didn't have criminal intent. It's not an allegation.
That's not the point of the statement. That's not the point. It refers to the uniform citation as a cause of action, sir.
It's not criminal. Stop.
Is the uniform citation a cause of action or not?
Yes, but it's not criminal.
Okay, it's a cause of action. Thank you, sir. Deputy O'Toole, did you file a valid cause of action?
Objection. It's called for a legal conclusion.
Sustained.
Sustained. So now the deputy is not allowed to make legal conclusions? I thought just a minute ago he was able to make legal conclusions. Now he's not?
Sir, stop. You're wasting your time. You're wasting your time. The deputy has stated on the record that he stopped you. He had reasonable cause in his opinion to stop you. He issued you a traffic citation in person. All the things that you've asked for are repetitious. It's not going to happen, sir. You got the ticket. The deputy did his job.
So he's not going to answer the question
No,
that filed a valid cause of
I'm
action?
saying the objection. He is not going to answer it.
Okay. Did I cause any harm on January 16th, sir?
Sir, that's not an allegation. The allegation is you were speeding, not that you caused harm.
Is this a civil allegation, sir?
Yes.
What are the grounds for standing for a plaintiff in a civil case, sir?
The facts.
And that would be, sir, the facts of what, sir?
That you were speeding.
Did I
Or
cause any
not
harm?
speeding.
Did I violate anyone's legal rights or cause any harm, sir?
Yes, you violated a whole bunch of people's legal rights by speeding. in violation of the law.
Is that hypothetical, sir, or what?
That's a fact. That's a fact of law.
Where is the plaintiff, sir? Where is the factual evidence that there's a plaintiff here with a valid cause of action before us?
Sir, I'm not going to address that, because that's argumentative. You have a ticket, you're addressing the ticket. Do you have anything else that you wish to ask this officer?
I have many things, sir. Yes, I do. Deputy O'Toole, you said you were familiar with the ordinances of the town of Lisbon. Is that correct? You are, okay. And I have a copy of the ordinances. Would you like to kind of give them to you so that you can refer to them as we talk?
Irrelevant.
The ordinances of the town of Lisbon are irrelevant, sir?
Yes, sir.
I think that the ticket should be dismissed because on the citation says that I violated the town.
You wish to ask this officer?
I do, sir.
Well, then ask it.
I would like to ask him about the ordinances of the town of Lisbon and their validity as applicable in this case, sir. Is not ordinance 4201 cited as the adopting ordinance that the town has invoked, is using to invoke the court's jurisdiction here today? I would like the court to take judicial notice of 4201 in the state statutes.
It's not in the state statutes.
In the town of, I take your correction.
Sir, you're very confused.
No, I'm not, sir. I made a mistake. I'm talking about ordinance 4201 in the town of Lisbon municipal ordinance. Except as otherwise, sir, can I put this on the record?
The court takes judicial notice of them, sir. I have reviewed them.
Okay. Except as otherwise specified, except as otherwise specifically provided in this code, the statutory provisions in chapters 340 to 348 and chapter 350 of the Wisconsin statutes describing and defining regulations, and it goes on and on. It starts, the first sentence says, except as otherwise specifically provided in this code. Deputy O'Toole, what does except as otherwise specifically provided in this code imply?
Objection calls for legal conclusion.
Sustained.
So, the town of Lisbon ordinances cannot
The deputy is not in
subtract.
a position, sir, to answer that.
Then, if the deputy is not in permission to make legal determinations, then I make a motion that the citation be dismissed. He can't make legal determinations and decide when to apply the law. This motion should be, the citation should be dismissed.
Court takes notice of your motion and denies it, sir. Proceed.
Okay. Well,
You have anything else to
I
ask?
do, sir. The penalties, what are the penalties as enumerated in the town of Lisbon municipal ordinances for traffic violations? Do you know what section 4205 says in the town of Lisbon municipal ordinances, sir?
Objection relevant.
It's not, it is relevant, sir, and I will go on to show.
How is it relevant?
Because they have adopted them, and here's what they say. Forfeitures.
How does the officer know that?
Well, if the officer is responsible, sir, there are no penalties. The town of Lisbon does not authorize any penalties for traffic violations, sir. Forfeitures for a violation of sections 340.01 to 248.28 Wisconsin statutes shall conform to the forfeiture permitted to be imposed for violation of the statutes adopted by reference, including any violations or increases for subsequent offenses. The range of code they cite is 340.01 to 248.28. I have the town of Lisbon ordinances right here. They have not correctly and in strict conformity with the Wisconsin statutes. They have not adopted the state statutes in strict conformity with the state law. In their section on penalties, they say forfeitures for violation of section 340 to 248 Wisconsin statutes. That is not a valid range of any of the traffic statutes. And I have copies of the ordinances here. If anyone would like to see them, they're online.
You know 346.57 too? Of the Wisconsin state statutes?
I do, sir.
Okay, that's provided for the bond schedule.
Only if the town of Lisbon has properly adopted the statute, sir.
They have. The court has made the determination after reviewing it, takes judicial notice that the town of Lisbon has adopted the state statute.
In their adoption, they stated that, except as otherwise specifically provided in this code. That's the first sentence of their adoption. And in...
Sir, we're not going to argue it.
I'm not arguing, I'm presenting the evidence, sir, that the codes don't apply, that they can't, there's no enforcement, there's no penalty, the town of Lisbon has no authority to impose penalties, nor do they have authority to enforce the ordinances. In section 4206...
You're overruled, sir.
In section 4206...
Sir, I made my ruling. You may appeal it.
The Wisconsin...
How do you... Come on, sir, let's go.
Okay, the Wisconsin statutes say, let me repeat what they say here, that authority to adopt traffic regulations in strict conformity with state law. This is State Statute 34906. Except for the suspension or revocation of motor vehicle operator's license, or except as provided...
Sir.
You're not letting me finish, sir.
Sir, I'm already made a ruling.
Yeah,
No, you're not.
it says that the traffic regulation, it says the traffic regulation must be in strict conformity.
My ruling, they have adopted them.
They're not in strict conformity with the state law,
So
sir.
then you appeal that. Proceed, sir.
Well, all I can say is that I'm attempting to present evidence that the town of Lisbon has not adopted the state statutes in strict conformity with state law. They have no,
Well, that has nothing to do with this officer.
he
Proceed.
issued a citation with demerits and deposit. He put data on the citation that is imposing a penalty upon me.
No less, sir.
He's trying to impose a penalty on me, and the town of Lisbon ordinances do not authorize the application of a penalty,
Sir, I
sir.
made my ruling. How many times do I have to make
Well,
that?
sir, I wish you would consult the town of Lisbon ordinances, which I have a copy of right here.
I have right here.
Okay, what does section 4205 say, sir?
Sir, I'm not going to argue with you. I made my ruling.
They have not
I
adopted...
have made my ruling.
Okay.
Proceed.
Sir, you stated that you did not have any further contact with Ms. Kershak after the court date. Is that, or no, you said that you didn't have any additional contact with me after you issued the citation. I'm sorry I asked that question poorly. Ms. Kershak asked you if you had any additional contact with me after you issued the citation. What did you respond to that?
They had no contact with you.
Okay, sir. So you do not recall the phone call that I made to you prior to the scheduled
That
trial?
was not the question.
Okay, let me ask the question then. Do you recall the phone call? I'm asking if you recall.
It's irrelevant.
It's a contact that
Sir, will you listen to me? We're talking about this ticket. Ms. Kershak's comment to the officer was, did he have any further contact with you that day? And his answer was no. Whether he had any contact with you after that is irrelevant to the issuance of this ticket.
Sir,
It's irrelevant.
I have a discovery motion.
I don't care what you do. Discovery is not allowed in municipal courts pursuant to statute, pursuant to chapter 800. It's not allowed in municipal courts. Your motion for discovery is denied. Proceed, sir.
That motion was already granted by Judge Kay, sir.
Judge Kay isn't sitting here, is he? This is Judge Cook, and I made that ruling. Now stop questioning me at this court. I'm making a record. You don't like it, you can appeal me. You have no right to discovery in municipal court. Judge Kay may have allowed it in his court. I do not allow it in mine. Denied. Proceed, sir. Do you have anything further of this officer with regard to this ticket?
The deputy, did you ask me at the time of the issue of the citation if I had any questions?
It is.
Okay. So you asked me if I had any questions. Did I ask you questions?
Yes, you did.
And are you characterizing me asking you questions as me arguing with you?
Yes, but it wasn't relevant to the matter.
Yes, I asked you if you had jurisdiction over me, sir. You specifically asked me if I had any questions, and I asked you if you had jurisdiction over me.
Sir, what difference does that make? You're here on a ticket. I have ruled the officer has the right. Whether you argue with him, he didn't issue you a disorderly conduct. He didn't issue you an obstructing. He issued you a traffic ticket for speeding. That's the issue before this court. Were you or were you not speeding? That's the testimony. And whether you agree with it or disagree with it, whether you're argumentative or not, the court ruled already the officer has jurisdiction. If you don't... I
know that you say the court ruled on it. I haven't seen the evidence, sir. I haven't seen the facts. If you found those facts, you made the ruling, what facts and evidence did you base that on, sir?
I have made the ruling.
Okay. Does hitting the hammer on the table make it more forceful or something?
It must be, sir, because you just don't get the message.
So it's violence here. That's the message I'm getting. That your laws are enforced by violence, not facts and evidence.
Anything else with this officer?
Not at this time.
You have anything further?
No, I have no further questions for this deputy to tell him rest.
Thank you. You may step down. Court has orders. All right, the town has rested, sir. Now it's your turn to offer any witnesses that you have. If you wish to testify, you may come up here and be placed under oath. I understand you're not an attorney. You can tell me what you wish to tell me with regard to this ticket on this date and time in question. You will be subject to cross-examination. If you do not wish to testify, you do not have to. It will not be used against you. Do you wish to testify, sir?
I do not wish to testify.
Do you have any witnesses?
I do, sir.
All right.
Sir, would you come forward?
I decline.
Sir, would you come forward?
No.
Well, it seems that there will not be any facts or witnesses presented today.
Thank you.
Sir, I'm not done. It appears that there will be no facts and evidence presented.
Thank you.
To establish that this court has jurisdiction.
Thank you.
There have been no facts and evidence presented. So am I going to be able to make my closing statement or not?
No.
No? I thought you just offered me that.
I have not offered you any indication of a closing statement. None whatsoever. I don't know where you got that from. We're in trial, we're in testimony. I asked you if you wish to testify, you said no. You're on the record. I asked if you had any witnesses, you have none. That's where we're at. Now, the testimony is closed. The trial is over.
I am not able to make
statement. I will allow 2 minutes for the town to make a closing statement. I will then allow Mr. Lozina 2 minutes for a closing statement.
Thank you, Judge. I believe the town has met its burden in this case by clear, convincing, and satisfactory evidence that the defendant was in fact violating the town ordinance, which adopts the state statute regarding speeding. Deputy O'Toole has testified that he's been in law enforcement for at least 2 years, that he was on duty on January 16, 2015, and he observed the defendant's vehicle exceeding the speed limit on the roadways of the town of Lisbon. He testified that he tested the radar unit before encountering Mr. Lozina and after, and that the radar unit was in proper working order. He testified that he got an accurate reading of the defendant's speed and subsequently issued citation. Based on those facts and the rulings of the court here today, I feel the town has met its burden, and the defendant should be found guilty of the citation as written, speeding $4,119.
Thank you. Mr. Lozina, you now have 2 minutes for a closing statement if you wish to use it.
Thank you, sir. This ordeal for me began back on March 13th, and I asked the court at that time if they had facts and evidence proving that the Constitution and codes of the state of Wisconsin applied to me because I was physically in Wisconsin. They failed to produce that information. I asked if there was any evidence of a complaining party. They failed to produce those facts and evidence. As of right now, in the record, there is no evidence of a complaining party. There's no evidence that I violated anyone's rights or that I harmed anyone. There's no facts and evidence on the record right now proving that the codes and statutes of the state of Wisconsin apply to me. All we have are opinions and legal arguments made by the prosecution and by the judge. And there are no facts, there's nothing showing when, where, why, and how the laws and codes of the state of Wisconsin became applicable to me. And I filed a motion for discovery, which is in the Wisconsin statutes, contrary to what you had said, Judge Cook. And this motion was granted, and I asked the prosecutor to present evidence showing that the codes and statutes of the state of Wisconsin applied to me, and she has failed to produce that evidence. And the discovery was also a Brady request, which compels the prosecution to find the evidence that I'm requesting, so that that no exculpatory evidence would be withheld. So all this citation of the law and the codes doesn't mean anything to me, because there's been no evidence of territorial jurisdiction, and there's been no cause of action, no evidence of a plaintiff. Therefore, there's no subject matter jurisdiction or no personal jurisdiction. So because there is a complete lack of facts and evidence in the record showing that this court has jurisdiction, I move that this citation be dismissed.
Anything further, sir?
No, sir.
Thank you. The court is prepared to make a ruling. The matter before the court is a traffic citation issued to Paul J. Muzina. It was issued on Friday, the 1st of January 16, 2015. It was issued by Officer O'Toole of the Waukesha County Sheriff's Department on assignment under contract with the town of Lisbon. The evidence before the court was that on the date and time in question, Officer O'Toole was on patrol. He was a certified police officer with the Waukesha County Sheriff's Department. He was properly trained in the use of a radar unit. He was operating the radar unit. He testified that he tested the radar unit before he made the observations of the defendant operating on Highway Q in the town of Lisbon, in Waukesha County, in the state of Wisconsin. That radar unit was operating properly. He took a radar unit, a reading of the defendant, and the rating was 49 miles an hour in a posted 30 mile an hour area. The officer testified that the area was posted 30 miles per hour, that the defendant would have had to pass the posting prior to his being cited by the radar unit. After the officer got the radar unit, he then tested the radar unit again, and the radar unit was properly operating. The officer testified that there was no other person in the range of the radar when he observed the defendant, Mr. Muzina, operating his motor vehicle and that date and time in question. Based upon that, the officer stopped the defendant. He identified the defendant with a valid Wisconsin driver's license as Paul J. Muzina. Mr. Muzina, on inquiry of the court, indicated that he indeed was the individual that possessed that driver's license, and he did have contact with the officer at the time in question. Mr. Muzina was cited, and the ticket was deliberately given in person on that date and time. Mr. Muzina has brought several motions before this court. He has brought a motion for discovery, which is not allowed by Wisconsin statutes 800 and 801, which applies to municipal courts. This is a traffic citation, not a criminal matter. Based upon that, Mr. Messina indicated that he was the possessor of a valid Wisconsin driver's license, that he obtained that Wisconsin driver's license, and is in possession of that at the date and time in question. Based upon that, Mr. Messina is subject to the traffic laws and the jurisdiction of the state of Wisconsin. The town of Lisbon has adopted the Wisconsin statutes, 346.575, through their ordinance 42.01. The court finds that Mr. Messina, on that date, voluntarily, without any cause, violated that ordinance and that state statute, and the court finds that he did in fact travel 19 miles, 49 miles, 19 in a 30-mile zone, 19 miles over the limit. The court finds him guilty, assesses 4 points against his driving record, will assess a fine of 119 days. As is the practice of this court, Mr. Messina will be given 60 days to pay that fine. If Mr. Messina does not pay that fine within the 60 days, a warrant will be issued for his arrest, and he will be sentenced to 3 days in the Waukesha County Jail under Huber for that citation. Mr. Messina, you have 20 days to appeal my decision. The clerk will give you that information. There is a transcript, voice transcript that's available upon the payment of $10. The court will copy the transcript to the town on a payment of $10. The court will provide a transcript to the court. Failure to do so, sir, you will lose your right to appeal. There being nothing further in this court is now adjourned, and the exhibits will be maintained by the court in the court's file. Thank you.
Thank you.